Good morning, students. So now I am going to start a very important topic of the Indian Constitution, that is Doctrine of Basic Structure. You all have a question why I am starting from this concept, that is Doctrine of Basic Structure, because that Doctrine of Basic Structure is very landmark principle in the Indian Constitution. After this principle, the entire trajectory of the Indian polity has changed. So, I am starting this topic from the doctrine of basic structure. It is very important policy. You will always get two or three questions in the prelims or one or two questions maybe in the mains examination. In the one day examination, you will also get some questions from this topic. So now we start the doctrine of basic structure, how it has been originated and what is evolution of this doctrine and what are the implication of this doctrine in the Indian constitution and polity. So before starting this topic, you have to understand certain concepts to develop a clear perspective of this policy, in what context this policy has been evolved. So now we are going to start the concept of doctrine of basic structure. Doctrine of basic structure. Doctrine of basic structure. What is this doctrine and how it has been evolved, and what are the implications of this doctrine in the Indian constitution, that we have to understand. Now, before starting this topic, I will introduce certain terms to you, that is the judicial review. What is judicial review? Where this term is mentioned, whether it is included in the Indian Constitution, it is implicit in the Indian Constitution, whether what is this term indicates. So here we want to clear that this term, the judicial review, this direct you will not find in the Indian Constitution, but this principle already exists in the Indian Constitution. It means this word you will not get, but the doctrine of judicial review already implicit in the Indian Constitution by interpreting the certain articles. So whatever the modern constitution you will get, where the written constitution is available, so here this policy is perhaps exist. ठीक है? तो Indian Constitution also includes the principle of judicial review, because the concept of modern constitution is the limited power of the government. But earlier the monarchy existed. What was the main principle of monarchy? That is absolute power. They are considered the representative of the god. Okay. So what in the modern constitution, in the modern concept of government, is that the government should have limited power. The individual or citizen should have certain rights to protect the system to become the anarchic. Okay. So the judicial review already implicit in the constitution. It means that if the government, if the parliament encroaches the rights of the citizen, then the judiciary have to play the role as a protector of the constitution and the interpreter of the constitution. So this doctrine of judicial review is already existed in the Indian constitution. It is implicit in various articles of the constitution. That is, I will introduce certain articles where this principle exists. That is Article 13, Clause 2. Here you will find this concept of judicial review. Article 32. Here you will find the concept of judicial review. Article 226. You will find this concept also here. And many other articles you will find the concept of judicial review. But I have given you certain examples where you can find this doctrine of judicial review by interpreting this article. So now from where the concept of judicial review led to the doctrine of basic structure, you have to link the doctrine of judicial review from the doctrine of basic structure. How the interpretation of the concept of judicial review will lead to the doctrine of basic structure, we are going to discuss this. Okay. Now, how it doctrine of basic structure originated? This you have to understand. Before starting this, I will give you the certain overview of the fundamental rights. The fundamental rights. Why these are called the fundamental rights? Because these rights are very intrinsic to the life. Very intrinsic to the life. Very intrinsic to life. It means that without these rights, you can't imagine a dignified or a decent human life. So these rights are very fundamental or very intrinsic to life. So these are called the fundamental rights, and it is very modern concept. Okay. So now these fundamental rights, from where this principle emerged. So we will discuss here that this principle has been emerged from a document called Magna Carta. From a document called Magna Carta, this document has been launched by the British Crown. By the British Crown. You all know that monarchy still existed in the Britain. So earlier the Britain was a system of monarchy. So it means monarchy has absolute power, the king has absolute power. Okay. So now what will do this? The British Crown wanted to implement certain reforms by giving the certain rights to their citizens. So they propounded a document called Magna Carta. Here, certain rights have been given to the British citizens. So here, this document become very landmark in the evolution of the fundamental rights. Now, what happened? You have already know that in the last 18th century, certain revolution were taking place. In the USA, the revolution happened. In the France, the revolution happened. So in each revolution, the people are demanding certain rights. Okay, so now in the USA, first and foremost, the USA revolution took place and their constitution drafted later. So in the USA constitution, you will find this concept of fundamental rights. You all find that this concept of fundamental right you will find in the USA constitution. So in the Indian constitution, we have borrowed the concept of fundamental rights from the USA. We have borrowed fundamental rights from the USA, and the concept of judicial review also have been borrowed from the USA Constitution. So these very important principles, that is concept of judicial review and the concept of fundamental rights, have been borrowed from the USA Constitution in the Indian Constitution. But we have to also discuss that whether the concept of fundamental right have been discussed in the Indian national movement. So it is very also we have to discuss. So here we are going to discuss that the discussion of the fundamental right whether happened in the Indian national movement. Yes, of course, the discussion on the fundamental rights had been happened in the Indian national movement also. There was a session of Congress in the 1931. There was a session of Congress in 1931 that was presided over by the Sardar Patel. That is presided over by the Sardar Patel. This session had been held in Karachi. That is had been held in Karachi. So in this session, the resolution on fundamental right had been adopted. The resolution on fundamental right had been adopted. So the resolution on fundamental rights had been adopted. So we will certainly discuss the Indian national movement in the modern Indian history. When we will discuss the modern Indian history, national movement is a very important topic here you have to understand, because in the national movement you will always find 3 to 4 questions in the prelims and as well as in the mains examination also. So we will discuss the modern Indian history after completing few topics of the Indian polity that are important before 12th October. Okay. we will certainly complete the Indian national movement. Okay. Now here you have understood that how the fundamental rights emerged. Okay. So from where this concept have come in the Indian Constitution, from these fundamental rights adopted. Okay. Now we are going to start a very important concept, that is the fundamental right. In the fundamental right, that is in the Indian Constitution, in part third. In the part third, it starts from Article 25 and concludes in the Article 35. So the fundamental rights are enumerated in the Indian Constitution in the Part 3, and it will start from Article 12 to Article 35. So from here the debate has been started, the what is the status of fundamental rights, and it will lead to the doctrine of basic structure. From where now in this context you have to understand the fundamental rights that starts from the article 12 and concludes in the article 35. Here very important article you have to understand, that is article 13 clause 2. That is Article 13 clause 2. What this article means, because the whole debate has been started by interpreting this article, that will lead to the doctrine of basic structure. So what the Article 13 clause 2 states? It states that states shall not make any law, state shall not make any law, state shall not make any law, state shall not make any law that takes away or abridges means to reduce the scope, that takes away or abridges the rights conferred by this part, the rights conferred by this, the rights conferred by this part. If state shall make any law, if state shall make any law, if state shall make any law, that contravenes to this clause, that contravenes or violates, any word you can write, that contravenes to this clause, that contravenes to this clause, then that law will be unconstitutional to the extent of contravention, to the extent of contravention, to the extent of contravention. So this article is very important, because this article will lead to the emergence of the doctrine of basic structure. The interpretation of this article has been started. Okay, so here we have to understand the word law, that is very important. The word law becomes very important. So now what this word law means? Here what happens, the word law, that is become very important. Now what happens, because now you have to understand the context of the what was going on in the Indian society when we became independent. What happens, already you know that if we were colony of Britishers since 200 years, and our economy has already been ruined completely. There was no industries. Our people were dependent only on the agriculture. So now what happens, even in the agriculture, that the land is very important input, you all know, and there was the prevalent of zamindari system in the इंडियन इकोनॉमी, ठीक है, जो भारतीय अर्थव्यवस्था में था वो उस टाइम पे क्या था, जमींदारी सिस्टम बहुत था। तो जमींदारी सिस्टम क्या होती थी कि जो जमींदार होते थे उनके पास बड़ी लैंड होल्डिंग होती थी, और जो पीजेंट्स होते थे, जो किसान होते थे, उनके पास बहुत छोटी छोटी लैंड होल्डिंग्स थी। तो जो कुछ ही जमींदार थे वो ऑलरेडी बहुत ज्यादा जमीन को कब्जा किए हुए थे। सो द गवर्नमेंट वाज थिंकिंग, गवर्नमेंट का विचार ये था कि वी हैव टू इम्प्लीमेंट द लैंड रिफॉर्म्स टू रीडिस्ट्रीब्यूट द लैंड to all citizens. That because the if you want to enforce the equality, if you want to enforce the concept of justice, if you want to enforce the concept of economic justice, then you have to empower the Indian citizens. So but that time only agriculture was the only mean to produce commodities. So if the people, large population had no land, then how will they sustain their life? So the government thought that we have to implement the land reforms. But here गवर्नमेंट हैड अ वेरी इंपॉर्टेंट हर्डल्स इन फ्रंट ऑफ द गवर्नमेंट। गवर्नमेंट के सामने सबसे बड़ी बाधा क्या थी कि आर्टिकल 13 क्लॉज 2, बिकॉज ये क्या कहता है यहाँ पे वर्ड जो लॉ है वो ये कह रहा है कि अगर गवर्नमेंट कोई लॉ आती है जो फंडामेंटल राइट्स का स्कोप भी कम करे या फिर फंडामेंटल राइट्स को ही टेक्स अवे किए करे, तो वो लॉ अनकॉन्स्टिट्यूशनल हो जाएगा। अब क्या था गवर्नमेंट के सामने, High government have to bring the land reforms, and if the government brings the land reform, then what rights it may violate? Indian constitution have certain rights that in the eve of the constitution, when the constitution drafted and implemented, Indian constitution contains 7 rights. So there 3 rights may be violated. What these rights may be violated? That is Article 14, right to equality. If the government will bring the land reform, certain people say that it is the violation of my right to equality, because you have to capture the land of certain people and don't have to certain, so that it may be violate the right to equality. Right to freedom, Article 19. Right to freedom, Article 19. And Article 31, that is right to property. Right to property. At that time, this Article 13 right to property was also the fundamental rights. Later, in the 44th Constitutional Amendment Act, this article has been replaced from the fundamental rights to Article 300A, and the current status of this right to property is that it is a legal right. Now it has been replaced from the right to property, but at that time this article was this right to property was a fundamental rights, and if you will implement the land reforms, means it government will confiscate or redistribute the land of the certain citizen, then it is the violation of the article 30. But then what was in front of the government of the at that time, how will they implement the land reform? So the only main government tried to implement the land reform is that they launched the article, the first constitutional amendment act, to bring the land reforms. So now the what happens here, the word law which had been used in the article 13 creates a debate. What debate it creates, I will certainly discuss in the next lecture, that the what were the contents of the first constitutional amendment text, what has been government amended in the first constitutional amendment text. Certainly government is going to amend the fundamental rights. Now what happens, but here the word which is the law word here creates the debates. What type of debates create? Because the word law has two connotation. इसके दो अर्थ है लॉ वर्ड के। एक तो जो पार्लियामेंट की पावर है कि पार्लियामेंट लॉ बनाती है, हर देश की पार्लियामेंट का प्रेरोगेटिव है लॉ मेकिंग पावर, बट द पार्लियामेंट आल्सो हैज द पावर टू अमेंड द कॉन्स्टिट्यूशन। ये भारतीय संविधान में ऑलरेडी दिया गया है अंडर द आर्टिकल 368। नाउ व्हाट हैपेंस, तो द वर्ड लॉ मींस टू कॉनोटेशन है। क्या है दो अर्थ इसके, कि एक तो ऑर्डिनरी लेजिस्लेटिव मेकिंग पावर, कि मींस गवर्नमेंट में parliament can make the certain ordinary laws, which is the prerogative of the ordinary law making power, और the दूसरी पावर है that is the constituent power to amend the constitution। टू अमेंड द कॉन्स्टिट्यूशन। तो ये दूसरी पावर है, इट इज ऑलरेडी इन द आर्टिकल 368 इट इज मेंशन्ड। ठीक है, तो ये दो कैपेसिटी पे यहाँ पे डिबेट स्टार्ट हो जाती है कि ये जो लॉ वर्ड है केवल कि ये ऑर्डिनरी लॉ मेंटेन कर रहा है जो सिंपल मेजोरिटी से बनता है, सिंपल मेजोरिटी से बनता है, कि either it is constitutional amendment act also it contains. So the debates revolve around this word law, whether the word law means it includes the ordinary laws or constitutional amendment acts, or it includes only the ordinary law making power. So now we will discuss this in the when the government will bring the first constitutional amendment act, and this amendment act has been challenged in front of the judiciary because it violates that certain rights have been amended. Now what the Supreme Court takes the stand on the interpretation of the word law. So we will discuss in this the interpretation of this word law in the next lecture, that is when the Supreme Court will give its judgment in the Sankri Prasad case. That case has been heard in the backdrop of the first constitutional amendment act. So now you all have understood, I hope that. Now thank you, we are discuss in the next lecture.